legal and regulatory framework. Laws and regulations in Morocco are adopted and applied in full accordance with international human rights standards. Aware of the fact that investment is a key factor to ensure sustainable and sustained economic growth, Morocco has liberalized its economy by easing procedures, providing better protection to private operators, through introducing new laws aiming at improving investment conditions and, thus, acquiring significant flow of domestic and foreign private capital, including labor code. This code matches the basic principles set by the Constitution and international standards, as spelled out in the UN conventions and its specialized organizations in connection with the work field. The protected rights include 1. Trade union freedom and effective adoption of the right to organize and to bargain collectively. Prohibition of all forms of work coercion. 3. Effective abolition of child labor. 4. Prohibition of discrimination in terms of employment and professions. 5. Equal wages. Protecting copyrights. The law on copyright and related rights anticipates measures that aim, on the one hand, to strengthen and modernize the protection system for creators and works, and on the other, to harmonize national legislation with commitments made by Morocco, as part of international treaties and agreements. The Moroccan Office of Copyright, the OMPEC, under the Ministry of Industry and Commerce, is responsible for the protection and exploitation of copyright and its sister rights. Protecting industrial property. The law on the protection of industrial property anticipates provisions for a brand opposition system as well as for border measures to control merchandise suspected of being counterfeit. It also covers the protection of sound signals and brand smells, and includes the deposit of brands in electronic format. What is more, as a signatory of international treaties on industrial property, Morocco has many advantages. These include a strengthened legal framework that protects industrial property rights for both national and foreign investors and conformity to the highest international standards in the field. The formalities for protecting the rights of industrial and commercial property, and applying international and national legislation are made at the Moroccan Office of Industrial and Commercial Property, the OMPEC. Freedom of pricing and competition. The 6-99 Law on Free Pricing and Competition sets the rules for the protection of competition and aims to boost economic efficiency, improve the welfare of consumers and ensure transparency and fairness in trade relations. The Competition Council is the body responsible for ensuring transparency and fairness in economic relationships, through the close analysis and regulation of market competition. It achieves this by attentively checking anti-competition and disloyal business practices as well as any operations that increase economic concentration and monopoly. Personal data protection. The law on the protection of individuals with regard to processing of personal data introduced a set of legal provisions aimed at protecting the identity, rights and individual and collective freedoms as well as privacy against all attacks that may affect them through use of computers. The law defines, among others and with precision, the right of access to databases containing personal data, to object to certain treatments, to request correction of erroneous data, and delete outdated information or those whose purpose of treatment was performed. The CNDP National Commission for the Control of Personal Data Protection is responsible for verifying that personal data is handled in an approved, legal way and its use does not carry a risk to private lives, freedoms or fundamental human rights. Arbitration and mediation. The arbitration legal arsenal is characterized by a series of innovations aimed at harmonizing the Moroccan trade law with international principles. Among the novelties of this paper are broadening the scope of arbitration to legal entities under public law. The implementation of the arbitration judgments relating to these acts remains, however, subject to the exequatur, which returns to the administrative jurisdiction in the competence of which the judgment will be executed, or in the Administrative Court of Rabat, when the arbitration judgment concerns the whole national territory. The text also gives the tribunal the right to rule, either automatically or at the request of either party, on the validity or limits of its powers, or the validity of the arbitration agreement. It can also take, at the request of either party, any interim measure it deems necessary within the limits of its mission. This law has also contributed to achieving an international quality of arbitration and provides conventional mediation as an alternative for resolving conflicts.